Hey guys, what is up? It's Dusty here, and welcome back to another episode of the Daily Crypto News today, only focused on the Ripple v SEC lawsuit, as there's a couple of things which have came out today. And of course, multiple different lawyers have let go their opinions and everything, but let's just quickly digest everything that's happened, and of course, what you need to know. So first of all, 6 hours ago this came out. The Ripple defendants have filed their response to the SEC's motion to seal its opposition to the amnesty request to participate in Daubert hearing. The SEC's motion to seal the amnesty response and the Ripple defendants' responses are below. Just to quickly give some context, we have to go back a little bit. Attorney Jeremy Hogan, for example, said Ripple lawsuit reaching endgame. Here's why. Well, let's quickly read this to get some context as to what just happened. Crypto legal expert Jeremy Hogan thinks the Ripple v SEC case is finally entering endgame. The move is a direct response. Actually, Hogan has responded to the news that attorney and XP supporter John Deaton recently filed a letter, an amnesty brief, requesting to represent the 67,000 XP holders. This is the amnesty brief. The move is a direct response to the SEC wanting to bring in an expert to testify on what XP holders thought when they purchased the sixth largest crypto asset. Hogan says the move could make the difference in the case. Quote, the judge granted XP holders amicus status, but they still have to make a request to the judge before doing anything. And here in this motion, Deaton requests leave of court to file an amicus brief in a Daubert challenge relating to the expert opinion of a Mr. Duty. Let's look at the page 1. Amnesty respectfully requests leave to file an amicus brief regarding the opinions of plaintiff's expert report, Patrick B. Duty. Daubert concerns related to Mr. Duty's opinions represent the precise nature of the difficult issues envisioned by the court when it granted amnesty status. Counsel for amnesty recently became aware of Mr. Duty's report, Mr. Duty, regarding the conduct of individual XP holders such as amnesty. Okay, context once more, because we have to dive a little layer deeper. John Deaton obviously is a XRP community member. He represents 67,000 XRP holders who basically became friends of the court, which is the amnesty cure we have read about a couple of times ago. So there's a expert. Again, there was a whole phase where both Ripple and the SEC were basically questioning experts. There's one expert named Duty over at the SEC side, or basically they question him, who says that for these and these reasons, XP holders bought XRP. And he basically referred to a reason which John Deaton looked at and thought, it's not really something which we think is true. So he basically filed to the judge to basically come into the case, as we are a friend of the court, right? We as XP holders, I guess at that point, to kind of explain, well, we as XP holders disagree with that, and we think that this is why we bought, for example, or this is why he is wrong. To understand a little bit more about the exact motion, though, we have to look at a couple of different articles, mostly the newer ones, and recall that on June 7th, so 2 days ago, the SEC pleaded with the court to seal its opposition to the amnesty brief due to safety concerns for Mr. Duty. And seal basically means they will know exactly what it is, but we as the public won't see it or won't be able to read much of it. Plaintiff SEC, this is the start of this newest letter, respectfully requests that the court order the sealing of the SEC letter in opposition to the motion by 6 XRP investors to file a brief regarding the opinion of one of the SEC experts, Mr. Duty, the SEC said in this newest motion. Now again, Ripple did not like that, because what the SEC is saying is, well, we think it's not so safe for all this to be open, and Ripple is saying, well, let's let it be open. Ripple basically have called on the SEC to redact portions of its opposition that may jeopardize the safety of Mr. Duty. Out of the 5 reasons the SEC cited, 4 of these concerns do not reflect such concern, Ripple argued. And while Ripple noted that the concern about Mr. Duty, they obviously understand, it demanded that the SEC should make public the 4 reasons that do not in any way risk the safety of the agency's expert. The rest of the SEC's objection to amnesty request to participate in the upcoming expert challenge should be publicly filed, Ripple argued. The blockchain company noted that the SEC sealing request should be narrowed down as it appears to be manifestly overbroad. And Ripple and individual defendants went further to highlight sections that do not contain any confidential information that should be publicly filed by the SEC, in line with the presumption of public access to court records. Again, this is a very public case, so the judge also understands a lot of this stuff needs to be as public as possible. I know I'm spending a lot of time on this, I know, but it's very important to get this context before we actually move on. This is mostly on the basis that the SEC has gone for a lot of delay tactics, but also for a sign everything away approach. What I mean with that is they try to seal way more things than are usually done, and this is coming from not an expert, but somebody who's kind of read himself into a lot of these cases. You don't want to know how much time I've spent analyzing this stuff purely to give you guys proper content. And of course, watching the Amber Heard versus Johnny Depp trial, it made me basically an expert on everything. Just kidding on that one, of course. But what we're seeing yet again is the SEC at some point made a little bit of a mistake. Again, this is my interpretation of events. Please take everything with a grain of salt, as I'm not a legal expert. I'm just looking at everything, putting everything into context, and then cross-examining all these lawyers and different pieces I could find on the internet about how the law works in the US. But the SEC made a mistake because they basically got themselves some info from an expert who doesn't actually seem to be an expert. When the amici, when basically John Dean and the XP holders came to clarify everything, they all of a sudden took a step back and are now thinking, wait a minute, how can we make sure that we give as least information as possible to not make ourselves look even worse? And I needed to give all this context because of the most recent filing that just came out, as the court denied the SEC's motion to seal and orders it to file by June 14th a redacted version of the brief and exhibits under seal, redacting information only to the extent necessary to safeguard information sought to be filed under seal. So what the judge now said is, well, we agree completely with Ripple in the sense that, it doesn't really make a lot of sense to just hide everything from the public. It's a very public case, which we saw, being represented again when people try to call into the freaking courthouse, but it was, I think, 4,000 max again, and you just could not call in. I, of course, had my little panic moment for anybody that watched the live stream. I digress. She wants it to be as public as possible, and she knows that the SEC is thinking the exact opposite, so they'll try to hide as much as possible because it hurts their image. Whenever they make a mistake, whenever they're wrong, whenever anything along those lines, they try to hide up as much as possible. Specifically, and this is just an assumption made by me, please do not attach any weight to this. Specifically, if they, for example, instructed the witness on what they were thinking, which made him change his narrative a little bit. I'm talking about him being biased, for example. Why am I saying that? Because at the end of the day, it doesn't make a lot of sense for this witness expert to come out and explain what XP holders were thinking when clearly it is not his best position to do so, as he's representing seriously maybe one at maximum, let's say 10 XP holders, where there's a John Dean who's right on top of his ass, right? Just right there, probably like a freaking, a hawk or freaking cheetah, just watching him like that to pounce on his ass. I'm not really sure exactly why he thought that would be a good idea. And now, of course, SEC is like, well, damage control was not. So, yeah, it makes a lot of sense that the judge didn't really fall for this trick again. I also think the judge is mostly going to rule with Ripple on a lot of these more trivially SEC just trying to make things more difficult motions. And the reason I say so is because they got caught with a lie. And obviously the judge is going to be a little bit more critical about what exactly the SEC puts in these motions and the reasoning for it. Again, this is just my assumption, but it's kind of a logical deduction, I think, right? If you're caught lying or changing your story all of a sudden, saying, no, we've had this mindset all this time, I think the judge will pay a little bit more attention to what exactly you're trying to say and hold a little bit more weight to it. So if you're all of a sudden saying, no, this really needs to be hidden because it's such a big, she's going to be like, yeah, but does it really? She's going to be a little bit more critical, I think, a little bit more on edge because of that very big mistake on the SEC's part. In the midst of it all, there was also this little update from Library. Again, Library is another case where a crypto token is involved with the SEC. It's just kind of closely related because it's SEC versus a crypto project. It's not actually regarding a Ripple, all right? Just so you guys understand. In the Library case, the SEC moves to strike a supplemental expert report, claiming Library is trying to correct defects in an expert report that were exposed in his deposition. I'm going to just let that one sit here. It's kind of funny. Jeremy Hogan said, is the same SEC that just violated the court's order on legal brief length? I didn't even know that, all right, guys, because, again, I'm not a professional in that regard. Most likely what they did, again, my assumption is they were supposed to file, let's say, 7 pages, and they filed 8 or whatever. They were supposed to file 3 pages, and they filed, a little bit more. Per Ripple's reply letter, this is Jeremy Hogan, we can get an idea of what is happening here. Seems, I'm assuming, there were hostile communications made to the SEC's expert witness, or perhaps just hostile online comments, and the SEC doesn't want their expert's physical address disclosed. I understand that. Very fair. Ripple is arguing that only one document exposes the expert's address, and only that one document needs to be sealed. I agree. If you communicate with the attorneys, judges, parties, or experts in the case, you are not helping. Trust the process, as frustrating as it is. One thing I want to make clear here as well, so everybody, is if you think it's a smart idea to go out of your way to threaten somebody or to harass somebody that's involved with the case, I'm not exactly sure what you think you're going to achieve with that, except for getting it off your mind. It's not really helping anybody, and most likely will just get more things hidden away from us. So I'm not really sure why you would do that. Then again, I'm not your dad. If that's what you want to do, I can't stop you, but I don't think it's a very smart thing. But yeah, that was it for today's little Ripple lawsuit update. Is it going to do anything for the price? Absolutely not. I guess I'm just like committed to the freaking craft right now. You know, I've done so many of these freaking lawsuit updates. It's like in my blood right now to give you guys the little context. Hopefully, you guys enjoyed it though. Hopefully, learned something new. I've been learning a lot about the law, man. It's actually crazy. Seriously, I never expected that I'd understand this much about how, I guess, lawsuits work from at least one, I guess, sector over in the U.S. I increased my vocabulary by a ton as well. And funny enough, when I was watching that Amber Heard trial, or at least parts before that as well, when trying to look into it a little bit, I really started to understand a lot more things. Because once more, guys, I'm not from the US or anything like that. But yeah, that was it. Thank you so much for watching. If you enjoyed it, subscribe to the channel. Make sure you press the like button. And yeah, check out the freaking Telegram down below.